Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Frank Doyle, and Frank is an attorney here in San Jose. He has his own company, WealthPLAN. It's a law firm specializing in estate planning, estate and trust administration, and estate and trust litigation. He's been practicing law for about 35 years, and he's certified by the California State Bar as a specialist in taxation law and probate, estate planning, and trust law. And as I recall, you're also doing some teaching at Lincoln Law School, isn't that right?
Right. You know, I've been the Wills of Trust professor for quite a long time. I think coming up on 20 years.
Wow. Well, good for you. Okay, well, the community appreciates you being there to get our new lawyers educated. So today, Frank and I are going to be talking about preserving family assets using a family limited partnership or family limited liability company, or LLC. And before we get started, I want to caution our viewers, as I usually do, that we're just covering a few highlights of an enormous area of tax law and rules related to estate planning using family limited partnerships and LLCs. This is just a bare starting point to learn about some of the issues, and we want you to get qualified tax and legal advice. This is not the place to stop for the information. It's the beginning of a conversation. And also, our discussion is going to be probably focusing mostly on California law, and the rules vary somewhat for other states. So again, you need to be sure that you've got legal support, in particular for the rules that apply in various states. So with that, Frank, let's get started. And first of all, thank you for coming and joining me as my guest again today.
Thank you for having me. I really appreciate it.
Yeah, it's my pleasure. All right. Well, as we get started in here, why don't we just get started a little bit for the environment? Is what is the status for the federal estate tax, and why should substantial individuals still be concerned about avoiding the tax?
Because there's a strong likelihood that it's going to go back to $1 million in terms of exemption next year. So what we have right now is kind of a real important opportunity period, okay? And then that period was 2011 and 2012, where we have a $5 million exemption, and that exemption is for both estate tax, gift tax, and generation skipping tax. And so, and that law is set to sunset at the end of 2012. And with the movement, or at least the sentiment in Congress, building that they want to reform the tax law, they want to stop tax breaks, so-called tax breaks for the wealthy. There's no guarantee. In fact, there's a strong likelihood that they're not going to extend this $5 million exemption, and so we're kind of in a use it or lose it situation this year. And many of my clients kind of recognize this and are moving to establish gifting programs, which typically include family limited partnerships. So the state of the federal estate tax law is, as it has been for the last 10 years, in flux. But rather than being in flux to the positive side, which it was for
during the
Bush administration, we're looking at it going the other way, the pendulum swinging, against those and in favor of, a death tax. So this is the year where we need to take advantage of really a rare opportunity. And one of the things a lot of clients, didn't understand, that this $5 million applies to gifts as well as, death situations. For years, there was a real disconnect between the gift tax exemption, which stayed at $1 million even when the estate tax exemption, grew up to 3 million and finally 3.5 million. And so this is really a rare opportunity to, to embark on some of these wealth transfer programs.
Now, one of the things too related to this, we talked about the exemption, but also the rate right now. The maximum rate is what, 35%?
It's 35%.
And then it could go up to like 55%.
It could go, so it's a 20% rate swing in addition to the exemption being lowered. So if they really wanted to hammer the wealthy, and I think this is a little bit alarmist, but it could happen, is they leave the exemption as it is on the books at $1 million, and then have the estate tax rate be 55%. That's going to really hurt a lot of people. At the same time, the net worth, at least in this valley of people, is on the rise, frankly. I mean, I see that there was a severe deflation of client assets starting about mid-2007, but there is a bit of recovery, and so that means that real estate prices are going up, and so you've got the value of people's estates going up at a time when the federal estate tax and gift tax exemption is shrinking significantly.
So there's another thing, and that is, I don't know, I haven't seen a real strong real estate recovery. It seems like real estate is sort of treading water.
Depends where you are.
Yeah, depending on where you are.
If you're in, I'll give you the parameters. If you're in like Atherton, Palo Alto, Menlo Park, Los Altos, Saratoga, Los Gatos, Mountain View, even.
A little stronger in these areas.
It's been more than a little stronger.
Yeah.
I think it's significantly recovered, and a lot of it is that's where the Google is. That's where Facebook is. And so if we have this Facebook IPO, and you have a lot of people with all of a sudden a lot of money, and they want to invest in residential real estate, I think there's going to, the prices are going to go up even further.
Well, and the other thing is we've seen something of a stock market recovery.
We have, yeah.
And so that also is a recovery of some of people's assets, but it's not up to the high, and so this is still an opportunity, even that the values. It's an opportunity as far as values being.
Yeah, I mean, last year really was the year if you wanted to transfer real estate, because the real estate was still depressed.
Yeah.
And so if you had, and now when you're dealing with commercial real estate, I think that's a different story. I don't think that has recovered as significantly, as residential real estate. But I think this is a real year of opportunity, particularly if you have commercial real estate or family businesses to move and get them transferred down to the next generation, or implement your succession plan.
Okay. So one thing, folks, just to let you know, when we're recording this is February 7th of 2012, and you'll probably be seeing this sometime later. So anyway, so just be aware. But what it means is that if you're going to do something, you're going to want to take action probably fairly quickly.
Right.
And there are studies that are involved and so forth that we'll be talking about. All right. Well, what is an approach aside from conventional estate planning that can result in a significant reduction of the tax?
Well, and I think it's this again, is to basically do what we call fractionalization or entity discount planning. All right? And what I mean by that is for a long time the federal courts in tax cases have held that the sum of the parts doesn't equal the whole. And what I mean by that, if you have a 10% interest in an entity, that merits a discount not only for its lack of marketability, but also for it being a minority interest, and that it really can't by itself control things. And for a number of years, the IRS tried to get legislation implemented to eliminate this discount. And they tried a number of different ways. all of which really didn't yield much success. So the concept that of minority interest and lack of marketability discounts, that concept is still alive and well. Now, one of the things that is out there is that the IRS is proposing, again, in this environment where we want to prevent the rich from getting any so-called tax breaks, they're trying to get legislation to eliminate the use of family discounts. Okay, and what they would like is they would like to have what you have in the corporate income tax area, in have family attribution. In other words, have a rule that says, we're going to treat, as long as these shares are held in the family, we're going to treat it, we're not going to allow any of these discounts. And to try to get that in by legislation. That's not going to be the law this year. There is not going to be any major tax legislation this year in an election year. So, these discounts, the courts, the law is right now, they're alive, well, and vibrant. And so again, this is another reason why clients really should, take advantage. For example, if we have a $10 million piece of real estate, and we, let's say, want to transfer a 25% interest in that. That's $2.5 million of gross value. Well, if we discount that by, a factor of, 40%, we're, getting down under $1 million in terms of value. And so that's the kind of thing that you really want to work with, so that you can get these discounts and transfer assets on what we call a leveraged basis, so that when we use exemption, we're not doing it for dollar, but we're using a discounted value, so that we get $2.5 million of real estate, transferred for a fraction of what it otherwise would be worth.
Yeah. So maybe we can talk about, well, I think what we want to emphasize here is this benefit can only be, the only way you can get it is by making gifts during your lifetime.
Yeah, well, right now, if you fractionalize, let's take that $10 million piece of real estate. Let's say we got 75% of it transferred down to the next generation through trusts or otherwise. So the parents now, own 25%. That 25% would be in their estate. But again, it's for estate tax purposes, it is entitled to the same discounts and the minority interest and lack of marketability discounts that you would get during a lifetime transfer. So the partnership concept has been an important one through the years, because what it does, it inherently reduces the value of what's retained, and by the same time, it reduces the value of what's given. And I think that combination of effect has been a tremendous estate planning technique, and kind of the axiom that we've operated by for a lot of years is you always want it, when you're using exemption, like when you're using that $5 million exemption, you want to use it on a leveraged basis. You want to use it not just dollar for dollar, but you want to use it through some kind of entity approach or fractional interest approach, where you get to transfer real value that is entitled to discounts.
Okay, so I guess I'll just reiterate. So what's we're talking about is that by giving an interest during your lifetime, and you're giving these small pieces,
correct,
then you're entitled to these discounts. If you didn't give them, then you'd have it. If you had a majority interest, okay, at the time that you pass away, then your estate wouldn't get any discounts, or minimal discounts. So by doing it during your lifetime, then your family is getting some real benefits.
Yeah, and this whole true is not to just, I mean, we're going to be talking more about the family limited partnership because it is really kind of the vehicle of choice for transferring, commercial real estate from one generation to the next. But, this concept of minority interest and fractional interest discounting applies to shares in a corporation, for example, or interest in a limited liability company. So the idea, I mean, I first came upon this, in the 80s. I was working with this family, and they had this great business, producing these particular spindles for farm machinery.
Okay.
And they were, the dad owned 100% of the business.
Yeah.
And yet the kids had really made it, catapulted it. The dad had gone out and he'd had this idea and he got a foothold, and then he sent his kids to college. He got one to be an engineer and he got one to get his MBA, and they came back, and they're the ones who for 20 years really bolstered the business. And the dad, of course, kind of, came into the office and talked to his friends and went out and played golf, but he owned 100% of the company. And I was explaining it to him. I said, hey, your every dollar of value you add to this, well, we want Dad to feel, like he's part of it. Well, it's one thing for him to feel part of it. It's another thing for him to, be in a position where your efforts are going to do nothing but, enrich the government. So that was the first family where we really kind of aggressively, fractionalized and transferred wealth on a succession planning basis.
Okay. Can you give too much?
Yeah, I mean, I think there's an old adage in tax law. Hogs get pigs get fat and hogs get slaughtered. Yeah. The other way around. And what you want to do is do things, or you can go to the Aristotle's golden mean, right? All things in moderation. And when I'm planning with working with a family, what I try to do is is tell them three things. There's kind of three other axioms that I use in counseling them. The first one is there's no one magic technique. Okay, there's no silver bullet.
Okay.
It's the combination. It's forming the family partnership, having the LLC as the general partner, and having the interests in the limited partnership typically held by trusts of some sort. Okay. So it's the combination, the system, that really counts. The other point is do not mix business assets with personal assets. And I think the number of the partnership cases that came down in favor of the government, where they basically said this is all a bunch of hooey, involved where people are putting their personal residence and their personal portfolio and their personal checking account that they're buying the groceries at Safeway on, and that doesn't work. So keep the business assets separate, because one of the requirements for family limited partnership to stand up to IRS scrutiny is you have to have a business purpose, and so that's a second thing.
Okay.
And the last thing is, don't be too greedy, and do things in moderation, and don't take ridiculous positions, and make sure that all your positions are carefully reasoned.
Okay. What should you consider putting into one of these family limited partnerships?
To me, real estate's the best asset. It's the ideal thing to transfer, building that's been in the family for, for years and years and years. I think that works very, very well, because the nice thing about the partnership is you can put commercial property, which is typically leveraged, and the partnership tax rules, as you know, allow for careful allocation of liability, so you don't have any taxable event going into it. And so real estate is really, to me, the premier asset. You can set up one with securities. The government basically says, wait a minute, why do you need a partnership to manage your securities portfolio? And there, when you really think about it, they've got a point, because especially if the portfolio is passively managed. If it's a hedge fund or something that the family is very active in, then that's another thing. But if it's a passive portfolio, you kind of run up against the business purpose. So to me, commercial real estate is the best asset to utilize the family limited partnership model.
Okay. What are some of the types of assets that the IRS and Congress are sensitive about, and maybe some of the different things about these that they really don't like?
Well, what they don't like is, as I say, personal assets is the big hot button. I think it's like there was a number of partnerships that were formed by the seminar crews coming in and telling everybody, well, the family limited partnership is so much better than the living trust, and let's put all your assets in your home and all your personal assets in a family limited partnership. The government basically has said that you need a business purpose, in effect, to have a valid family limited partnership. So personal assets. They don't like securities portfolios, for the reasons that I said. They say these are passive assets. If this is your securities portfolio that you're you're having managed and just moved into a partnership, and there's really no business purpose for it, they will they'll scrutinize that. So those are the two, I think, main hot buttons that the IRS has in terms of
I think the other one is
assets.
like paying your personal bills out of it.
Well, that's personal. That's that whole, you don't
Yeah.
mix your personal with your, with the business part of it. Where we've withstood a number of audits on these things, because the IRS, basically, wants to make real sure that these things have a valid business purpose, that the valuations are solidly based, and that the real hot button they have, and the way they've attacked these, is where the management is, has been retained substantially by the senior generation. Maybe we should talk a little bit about that.
Okay. Well, why don't you talk? We only have about 5 minutes left, so
Okay.
things are going fast here.
They're going to accelerate.
So why don't you talk a little bit about this issue of control?
Well, the IRS for years just got hammered, frankly, over and over again, trying to take the position that for some the minority interests and lack of marketability shouldn't be allowed. There should be some kind of family attribution. There should be some kind of amalgamation of values, and the federal courts basically said, that's not true. Here's the way the law reads. It's what's given that you value it. This is what has been given. This is, it's been professionally valued. We're gonna treat it as we're gonna hold these discounts are valid. Mm-hmm. Okay, and maybe they shave the discounts, maybe 2 or 3 or 4 or 5%, but as a concept, the idea that you had to value the 10% interest, you couldn't amalgamate it with what to the other members of the family. You're entitled to a minority interest and lack of marketability interest, which typically range from 35 to 50%. So those are the discounts. That was the environment they were in. Well, the IRS looked around and saw somebody there finally probably read 2036.
Mm-hmm. Section 2036, Internal Revenue Code section.
Yeah, and what that says is that if you retain an interest in a property that you transfer for less than bona fide consideration, which these would be typically, you're gifting the interest in the partnership. If you retain an interest in it, then it's going to be in your estate. So the first place that they attacked was where the people basically set all this legal paperwork up, but nothing ever changed. Everything stayed the same.
Right, so they didn't even change the bank account.
They
or
wouldn't
the
change
title.
the bank account, yeah. So these are the bad fax cases.
It was really bad.
Yeah, and those are easy to understand. And
Uh-huh.
and where somebody transfers something and retains an interest or nothing changes,
Right.
you're
not going to give it a
that's easy. But where they're really been sinister and where we're really worried is where if you really read 2036, what it says is, if you retain the right to decide who gets the income or the principal with anybody else, okay, it's going to be includable. And it's almost one of these things where, well, wait a minute, if you are a trustee of a trust, and you retain a right, and you have no interest, no beneficial interest in the trust, but you have a right to decide who's going to get the income, then it's includable in your estate. Well, yeah. Well, they're applying that to the partnership concept. They're trying to say, well, a general partner in a partnership has such power that it's akin to being a trustee of a trust where you can spread the income around your family members. And so when you're structuring these partnerships, what we try to do is make them true succession plans, and have an entity like an LLC be the general partner, and have the senior people that are transferring it have nothing to do, no ownership or no management. They step back, and let the kids, let the kids manage it. And I think that's a real critical issue that is posed a lot of practical problems, but I think that is one that you really have to be careful about when you structure these partnerships.
Okay. Frank, believe it or not, we're pretty close to out of time.
Well.
So anyway, I think we've had a pretty good conversation here. Folks, we've given you some basic information. Need to get some good professional help. This is not a do-it-yourself project. You need to get professional appraisers and valuation specialists, business valuation specialists. We've had other interviews with business valuation specialists here on the show, and get good legal advice.
Right, and it's something that you want to do for a substantial property. In other words, if you have a regular rental property that's worth a couple $100,000, it's probably not going to be worth it, because you do have to get these appraisals. You do have to have the thing properly structured. But if you've got a property that's worth a couple $1 million, and you want to try and get it down to the next generation, it's the way to go.
Okay. Frank, thanks for being my guest. Folks, thank you for joining us today. Hope to see you next time on Financial Insider Weekly.
Okay.